This is the matter of Jackson, Ireland. This is a continuation of the preliminary hearing. We were last here, I believe, in the middle of July. We adjourned that matter to allow parties to obtain counsel. And so we have a probable cause determination or a waiver to be determined today. Counsel, how do you wish to proceed regarding that?
Your Honor, the court is familiar with this case. This is a newborn. We had a jury trial on a prior children in this case. Having litigated with my client previously, I anticipate he will request a contested probable cause hearing and a jury trial with respect to the newborn.
All right, thank you. Mr. Brown, as to your client?
Your Honor, if they are going to have the probable cause hearing, we might as well just wrap up Ms. Ireland in that as well.
All right, that's fine. Mr. Sommerfeld, do you have witnesses for me today?
Yes, I'd like to call the petitioner, Ann Sullivan.
All right, Ms. Sullivan, would you raise your right hand so I can swear you in, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can put your hand down. Please state your full name for the record, and then Mr. Sommerfeld, go ahead.
Ann Sullivan?
Ms. Sullivan, can you hear me okay?
Yes.
All right, thank you. How are you employed, ma'am?
I am a CPS investigator for the Otsego County Department of Health and Human Services.
Are you familiar with the Jackson, Ireland?
Yes, I am.
And what's the approximate age of Jackson, Ireland?
He is just over 1 month old.
And where is he domiciled?
He's currently residing with his mother here in Otsego County.
Okay. So, and again, can you identify the mother by name?
Yes, mother is Kendall, Ireland.
And can you identify the father by name?
Cody, Ireland.
And you see both of them on the Zoom screen this afternoon, don't you?
Yes.
Okay. Tell us about this petition. I know we have jurisdiction over mom and dad here with other children, and then this child was born. Give us some background how this started out, because this did not immediately result in a petition to the court regarding Jackson. Is that correct?
That is correct.
Okay.
Jackson was born at DeVos Children's Hospital down in Grand Rapids. A complaint was received the day that he was born because Kendall and Cody both continue to have children in foster care. So that was received as a placing a child at unreasonable risk complaint. I had talked to the hospital. I talked to the foster care worker. There were some concerns at the hospital, but not anything major or immediate concern for Jackson's health or welfare at that point. It was noted by hospital staff that Kendall had put a safety plan in place that Cody was not to be left alone with Jackson. She wouldn't tell hospital staff why she wanted that in place, but that was something that she was adamant she wanted in place. A courtesy request was sent to Kent County. So Kent County CPS interviewed both Cody and Kendall while they were at the hospital. Again, Kendall was very adamant that she wanted in the safety plan that was created that Cody was not to be left alone with Jackson. Approximately a week after Jackson was born, we did receive word from Kendall that she was allowing Cody to watch the baby while she was sleeping during the day, which ultimately was violating her own safety plan that she had created. So at that point, we kind of looked at the situation, again, talked to foster care. Cody only recently went to jury trial in June. So he's not participated in any services. He's not rectified any of the barriers that brought the children into care initially. I also was able to obtain Cody's medical records. And looking at those, it did appear that alcoholism was a major barrier to him getting the kids reunified. So at that point, we decided that it was in the best interest of Jackson to file a petition removing him from Cody's care and requesting in-home jurisdiction for Kendall.
Okay, so tell us about the other children that are already under the jurisdiction of the court for both mom and dad. What were the conditions that brought them into care? A removal petition filed regarding Cody and Kendall Ireland.
In July of 2024, we had received, I believe between May and July, we had received a couple of complaints regarding housing conditions. And again, they were assigned for placing a child at unreasonable risk. Housing conditions were very poor, unsanitary, dog floor with an infant. I believe that Liliana was an infant at that time and was getting to the point where she would be crawling. There's a floor that she could have easily had access to if she was on the floor. There was an unlocked gun in the home that could have been accessible to Chloe. Kendall had reported some domestic violence between her and Cody, and she didn't feel as though it was safe. There was a lot going on at that time, which led to that initial removal of the children.
Okay.
Mr. Summerfeld, let me interrupt for just a second. Ms. Ireland, I do see that you have your hand up and you need to say, or want to say something. I'm going to let Mr. Summerfeld continue with his questioning, but I will come back to you in just a minute. Is that something that you need to talk to your attorney about, or is that something that you need to bring to the court's attention?
Yeah, I would like to go into a breakout room with my lawyer really quickly, please.
Your Honor,
Well,
I wouldn't mind doing that. I would like to hear the testimony first.
I wanted to see, Mr. Brown, if you were able to object to some of the questioning, considering this is a new case with my newborn and it doesn't necessarily pertain to my old case. So I just.
Okay. I'm going to let you have a chance to speak with him about that once the testimony is completed. So if you have any other objections, go ahead and write them down and he can then voice those things to you later. But as of right now, prior treatment of one child is relevant under the state statutes and case law to potential treatment of another child, especially if they're close siblings. That's a fairly well-known rule of law. So at this moment, your objections overruled and will continue, but I will put you in a breakout room in just a minute with your attorney. Go ahead, Mr. Summerfeld.
Thank you, Judge. Yes, Sullivan. So before filing the petition, wasn't there like an additional safety plan once the department found out that Cody, the father, was having this contact and then it was violated again? So we got the one from DeVos and then we got the one later on here in Otsego County.
So there was the safety plan that Kendall put in place with the nurse at the hospital. Then there's also the safety plan that she created with the CPS worker in Kent County. And then there was also a foster care safety plan created.
Okay. And again, really the crux of the matter, mom, Miss Ireland, Kendall, she would be sleeping and that would leave Cody unsupervised with Jackson.
Correct.
Okay. Now, when we were talking about the history with the prior case, wasn't that the same issue of leaving that Kendall allowing Cody to have unsupervised contact with the children? Wasn't that also creating issues in the first case, the first removal?
It was, yes, that was part of the initial removal.
Okay, so in essence, now mom has been participating in services after her plea.
Yes, she has been participating and successfully completing services.
Okay, but really, this whole incident shows the behavior that really started the first case with Chloe and Liliana.
Correct.
So you're asking for removal of the child from Mr. Ireland,
Correct.
and you're asking for in-home jurisdiction for mom, Kendall Ireland.
Correct.
Okay. And really, what is the distinction there? Why are there two different requests for relief?
At this time, their foster care case is on two separate tracks. Kendall has been participating in services. She has been doing very well with services. It is anticipated that the other two children will return to her care in the near future. She has been working really hard to rectify her barriers and to have the children return to her. Cody is not on the same track. He's only gotten to the point of adjudication. And to my knowledge, the last I've heard, he was not actively participating in services. And he's not rectified the barriers that brought the children in care initially.
Okay. Now, these are questions regarding Jackson, Ireland. Is custody of Jackson with the parents, and this is really for the issue of Mr. Ireland, does that present a substantial risk of harm to Jackson's life, physical health, or mental well-being?
Yes, it does. At this time, Cody's other two children still remain in foster care. He's not rectified any of the barriers that brought the children into care. So therefore, Jackson would be considered a substantial risk of harm if he were to be in Cody's care.
Okay, and is there any provision of service or other arrangement except removal of Jackson that is reasonably available to adequately safeguard Jackson from the risk you just described?
There is not at this time.
And is it the same reasons as before about being offered services, not participating in them? And so essentially the barriers, there are still barriers that he has in front of him that prevent the safety of the, caring for children at this time.
That is correct.
Is continuing Jackson's residence in the home contrary to his welfare?
Yes, it is. Cody did not voluntarily participate in any of the services to rectify the barriers that brought Chloe and Liliana into foster care. He still continues to consume alcohol, and he's not able to properly care for an infant child while he's under the influence of alcohol.
Okay. Consistent with, excuse me, Judge, consistent with circumstances, were reasonable efforts, were they made to prevent or eliminate the need for the removal of Jackson from Mr. Ireland?
Yes, Cody has had previous CPS cases. He's had services offered through the foster care case. A referral was made to Catholic Human Services for a substance abuse assessment. He also had a referral made for a psychological evaluation. He's been participating in supervised parenting time, and he's been offered parenting skills classes through New Life Pregnancy Center.
Okay. Are conditions of Jackson's custody away from Mr. Ireland, is that adequate to safeguard Jackson's health and welfare?
Yes, it is. Cody has not rectified the barriers that, again, brought the other children into care. He continues to use alcohol to excess, which hinders his ability to properly care for an infant child.
Okay. And you and I had talked about this, but we want to amend our petition as to allegation number 5, there are two, it's 5, two little I's, where it says, it's the last sentence, reporting that under no circumstances was Cody. You want to remove that NOT there, that not, so that Cody is under no circumstances was Cody to be left alone with Jackson. That's what you would like the petition to be amended to.
Correct.
All right, is there anything else you'd like to offer today?
Not at this time.
All right, thank you, Judge. I have nothing further.
All right, Mr. Brown, do you wish to consult with your client now, or do you want to wait until after Mr. Delaney's cross-examination, or how would you like to proceed?
I can probably consult with her briefly right now, Your Honor.
All right, we'll take a short recess, allow counsel to meet with his client in a breakout room. If everyone else would just kind of hang tight, Mr. Brown and Ms. Ireland, we'll put you in a breakout room now. Go ahead, Mr. Delaney.
Oh, thank you. Since Jackson is only a month old, there has not been any abuse or neglect perpetrated by Cody. Is that correct?
That is correct.
For lack of a better characterization, the department would be using the old allegations, which are more than a year old, to support the new petition.
Yes.
All right, I have no further questions.
Mr. Brown, your cross.
Thank you, Your Honor. Ms. Sullivan, how old did you say Jackson was?
He's just over 1 month old.
Old. And how was he born? Natural birth, cesarean section?
I believe he was a C-section.
And when Miss Ireland returned home, was she given any pain medications for the cesarean?
That I don't know.
Was she allowed to take pain medications?
Yes. I don't know that there's anything prohibiting that.
Okay. You said that it's still an unreasonable risk. Well, let me back up here. How many times did Cody watch Jackson?
That I'm not sure of. Kendall just reported that she was allowing him to stay at the home while she was sleeping, but she didn't tell me how many times that she allowed that to happen.
Okay, where was Jackson at the time?
That I don't know. I was not there when she was allowing that.
How long did she sleep?
That I don't know either. She didn't report that information to me.
Is that the only reason the court is seeking jurisdiction for Jackson?
Well, that, and just because, there were concerns about, whether or not I guess, I know that the children are on track for reunification, but I don't know how long that timeline is. I mean, she's doing well, but essentially if it's going to be 3 or 4 months, then we would want that in home. If it's going to be a week or two, that's a different story. But if it's going to be a matter of a few months, I think that just the in-home helps maintain the safety of Jackson in the home.
Okay, well, Jackson is in the home, correct?
He is, yes.
And he's in the home 24 hours a day, correct?
I believe so.
You said that leaving Jackson with Cody shows the behavior that brought the first case. What has she done that in this case that she did in the first case?
So essentially in the first case, what ultimately led to that removal was Kendall left Liliana in the care of Cody. She had cameras on Cody and Liliana. And there was a point in time where there was unsafe sleep happening, and Kendall thought that she saw on the camera where Liliana was suffocating due to the unsafe sleep. So essentially, in this particular case, Kendall was leaving Jackson, an infant. Liliana was an infant at that time as well, in care with Cody as she did previously.
But again, you don't know how long, how many times, and where Jackson was.
Correct.
And you're stating that she was allowed to take any kind of pain medication that she received, correct?
I believe so. Substance abuse was never an issue with Kendall, so I don't believe that there'd be any concern for her taking pain medication.
All right. Do you have any evidence that Cody was drinking at the time that he was there, notwithstanding you're not sure how long he was there?
I don't have any evidence that he was drinking at the time that he was in the home.
And how did you find out that he was there?
Kendall reported it.
He reported it?
Yes, she did.
I have nothing further, Your Honor.
Ms. Hansel, do you have any questions? I'm sorry, ma'am, you're still on mute.
I do apologize. I think I've got a bad connection. I'm on mute.
No, you're good now.
I'm good.
Yes.
Okay. I'm really sorry. Just to clarify, I don't know that I have all the paperwork, but is the agency seeking removal of Jackson at this point from the mother?
No, only from the father.
Only from the father. Okay. And prior to the father caring for the child while the mother was sleeping, was she aware that that was prohibited, that he should not be doing that?
She's the one that created the safety plan stating that he was not to be left alone with the baby.
Okay. But you did say she self-reported the fact that he had been alone with the baby?
Yes.
When you say when I refer to alone, that's when the mother was sleeping, correct? She wasn't out of the home, was she?
Correct. It wasn't that he was alone with the baby. It was more unsupervised.
Okay. Okay. I have no other questions. Thank you.
Mr. Sommerfeld, any follow-up questions?
Just to clarify with Ms. Sullivan, the request for in-home jurisdiction for mom is basically to monitor things. She's doing services, completing, reducing the barriers that brought the children in the care, Chloe and Liliana. It's just more of like a monitoring.
Correct.
That's a fair characterization.
Yes.
And then with dad, really the issue for removal is that the issues that brought Chloe and Liliana into care over a year ago, none of those barriers have been reduced by Mr. Ireland.
Correct.
And it's the fact that the unsupervised contact with Jackson, that would present that risk of harm because there's been no progress in the barriers that that resulted in the removal of his other two children.
That is correct.
I have nothing further.
All right. Do any of the other attorneys have any short follow-up questions for this witness?
I have one brief one, Your Honor.
ahead.
Mr. Sommerfeld just asked you if the reason for in-home jurisdiction was to monitor things. Is that correct?
Yes.
What additional monitoring is being put in place that is not already in place with the other children?
Essentially, the foster care case is only at this point is only in regards to the other children. So there's not anybody essentially monitoring Jackson. It is for Kendall and the other children. So the in-home jurisdiction would provide that level of monitoring of Jackson while they're in the home.
So it's monitoring Jackson, the 1 month old?
Yeah, well, it'd be Kendall and Jackson, but at this time he's not essentially.
So
And-
Kendall is not being monitored in the other case?
She is, yes.
Okay, thank you. I have nothing further.
Anyone else? All right. Thank you, Ms. Sullivan. I have no questions. Mr. Sommerfeld, do you have any other witnesses or evidence?
I do not.
Mr. Delaney, do you wish to adduce any evidence or witnesses?
No, thank you.
Mr. Brown, any witnesses or evidence?
I would like to briefly call Kendall Ireland.
All right. Kendall, I see that you have a child in your arms at the moment. Are you able to testify doing that?
Yes, Your Honor.
All right. I won't ask you to raise your right hand, but do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Go ahead, Mr. Brown.
Thank you. Ms. Ireland, you've heard the testimony that you left Cody alone with Jackson, correct?
Yes.
Was Cody the only one in the home with Jackson?
At the time, his mom had also been there as well.
Were you in the home?
Yes.
And where were you?
I was sleeping next to Jackson while he was in his bassinet,
Where was the bassinet located?
right next to me.
And do you remember where Cody was at the time?
Cody originally had started off by taking a shower, and then he was also in the same room as us making lunch.
How many times did he come over?
Approximately maybe 3 or 4.
How many times were you sleeping at the time?
Maybe 1 or 2.
And approximately how long were you sleeping?
The first time was only a half an hour, and the second time I was in a separate room with the door closed and he was next to me, and that was probably a 3-hour nap.
When you say he was next to me, who do you mean?
Jackson
Jackson
in a
was next-
bassinet.
In the bassinet.
Yes.
Do you recall if Cody was drinking while he was there?
Cody was completely sober. That was part of the conditions, is that he had to be sober if he was going to be there.
But at no time was he ever actually alone with Jackson.
Correct.
Do you have anything else you would like the court to know?
Yes, the timeline of events on which Miss Sullivan is recalling things is not necessarily the order of how things went as well. She also had told me before I even had admitted of Cody being there at any point in time with me sleeping. She had already told me that her plan was to remove Jackson from Cody's custody and care. She also had a second phone call as well for me.
Would you ever leave Cody alone with Jackson? I mean, alone.
No.
Thank you. I have nothing further, Your Honor.
All right. Mr. Sommerfeld, do you have any questions?
Yes, Miss Ireland, can you hear me okay?
Yes, I can.
Okay. Haven't there been incidents of domestic violence between you and Cody in the past?
Not to an extreme extent, mainly just verbal altercations.
Okay, didn't you make him leave the house at one point and he promised to go to like anger management classes?
No, that is not true. I left the home.
So, and as far as didn't you leave Chloe and Liliana in the care of Cody that caused some issues in the first case?
With Liliana, yes. With Chloe, no. At the time, Chloe was living with her grandparents.
Okay, and Liliana was just pretty much a newborn at that time.
No, she was 5, almost 6 months old.
Okay, and then didn't you report to the cops back then that you thought that Liliana was suffocating and that someone needed to go over to the house and check on that because Cody was not he was not awake?
Yes, I did.
Okay, and that basically turned out to be a false alarm, right?
No.
What do you mean by that?
I mean, I physically saw my child underneath blankets, and so did the medical director that was standing next to me. And I also saw her stop moving, completely wrapped under a blanket.
Okay, and Cody was supposed to be watching that child at that time while you were at work.
Yes.
So, somehow do you think that Cody is in a better place to parent now than he was about a year ago when that other stuff was going on?
Yes, I do. He has learned how to actually properly ask for help. He has also obtained separate things for his household to provide safe sleep for Jackson. He's also had several conversations with the foster care worker when our case was together about how to avoid things happening in the future because we knew I was pregnant. So they had done some planning.
So, but Cody hasn't done any services throughout the case. I know he doesn't have to, but he hasn't done anything for the benefit of his children.
That
Right?
is also not true. He has made 2 separate appointments. He has made one for the psychological evaluation IQ test. He has also made a appointment for his drug assessment test. He also has made an appointment and had a discussion and a consultation with his doctor about how to go about weaning himself off alcohol because he was instructed not to go cold turkey, otherwise it would further impact him medically. And he also has started doing parenting classes through New Life.
Okay, so other than a few appointments, when you say that he's made appointments, he has not yet done those things.
With the dates being as far out as they were for the IQ test, psychological evaluation, and the substance abuse assessment, yes, he has actively done parenting classes that he could provide proof of, and he has actively gone to his doctor in person, went to them, talked to them, and they made a treatment plan on how to go about it for him to start detox.
And so when has he done this? I mean, it's been over a year. What time frame are we talking about?
He has done this in the last month.
So in your mind, Cody is able to parent safely, and we shouldn't, when I say we, the department, you think we shouldn't even be involved here?
I do not think you should be involved. Cody also has an amazing support system where if something was, if he got stressed out or needed some additional help, he does have already pre-approved people that he could go stay the night with if it came down to it. Just like me, I'm a new mom of an infant. I stay the night places occasionally. So no, I think he's actually better. He is in a better place mentally, physically, and he is actively trying. He's also actively been sober for an entire week now, which I know in the court's eyes might not be amazing, but considering I was married to him for 5 years, he's actually making improvements. I would leave him with Jackson.
So how would you describe his drinking prior to a week ago?
He was weaning himself down. It does take time.
What about during the 5 years that you've known him?
I think significantly he realizes what's at stake, and that has changed his behavior. It was kind of an influx of ups and downs throughout the 5 years we were together. But I think he's actively trying, and I do see a difference coming from my mother, who was an alcoholic. I actually see the improvements in him that I saw in my mom before she actually completely got sober 110%, meaning like in lengthwise, not necessarily like sobriety wise, but like in the time of length that my mom took to actually completely stop. I think he's at that point where he will completely stop.
So have you seen him intoxicated before?
I have seen him intoxicated before in the past.
Okay, so have you seen him intoxicated around the children?
Not currently, no.
Okay, but in the past with Chloe and Liliana?
He was not left alone with them when he was intoxicated. I was always sober and awake, and if it got to the point where I needed to go to sleep, we were leaving, going to a friend's house.
Okay, and you're aware that Cody has been admitted to the hospital before for alcohol poisoning on more than one occasion?
Yes, I am.
I have nothing further. Thank you, Ms. Ireland.
Mr. Delaney, questions?
No questions. Thank you.
All right. Anything else that you wish to adduce, Mr. Brown?
Just one brief redirect. It was asked if you believe Cody was in a better place now. Things were brought up about this first case. With the other children, was this after or prior to receiving all of the services that you've received in the last few months?
I don't understand your question.
After the first case began, you have received myriad services and taken advantage of them, correct?
Yes,
You believe you are in a better place now.
I do. I firmly do. And I'm also at overnights. And at the end of the month, I actually get them for a 3-night overnight. I have been doing one overnight a week. I got bumped up, did that for a couple weeks, got bumped up to 2 overnights a week. And then at the end of this month, if things continue and I don't push the brakes myself, I will have them back overnight 3 days a week. And coming September, if things keep going on track, my foster care worker has stated to me that I will have them back in my care full time.
Thank you. Nothing further.
All right. Ms. Hansel, is there any witnesses or evidence that you wish to produce?
I do not. I have one question for Miss Ireland, though.
Go ahead.
Okay. Miss Ireland, is it still your intent to follow through with a divorce from Mr. Ireland, or is that has that been set aside now?
No, I still plan on following through with that. I am currently going to be filing part 2 of 1. We had FOC court that has been adjourned and pushed out to a later date because they would like to see where the NA case goes. They don't want to determine custody until after this case is closed. So I have a follow-up in, I think, September to see what happened at this court hearing. Where
Okay.
Mr. Ireland had also said that he was going to give me full custody. So I don't know if that's still his intent as well. We just have to kind of play out the NA case first.
Okay. Thank you. That's all I have.
All right. Closing arguments, Mr. Sommerfeld?
Thank you, Judge. Judge, Ms. Sullivan has made clear that this is a removal petition for Dad. That's based upon the violation of the safety plan and barriers that have not been rectified for other children that have recently been resulted in jurisdiction. We just had a trial. As far as Mom goes, we know that she's making progress. However, the in-home jurisdiction was added for Jackson just because of the issue of the safety plan. This was some of the same behavior that was happening in the first case. Although she is making progress, and I am aware of that, and that is a good thing. She has the child, and we're just looking to monitor. And I mean, if things are going well with Chloe and Liliana, we're not expecting anything else. But like Ms. Sullivan said, we can make Jackson part of a in-home service plan that includes specific services for a newborn child that were not present before. Both parts of the statute are probably met at different degrees, 2B1 and 2B2. But this is really more of like, this is an anticipatory neglect. Ms. Sullivan said, we didn't have the same type of issues that we did in the first case where the supervision from dad was resulting in bad instances where they put the children at risk. The risk here is that he has not done any services yet, and I mean, if he had done services and he was in a better place, Miss Ireland believes that he's in a better place, but the department has no information about this, and we have nothing to report to the court because nothing has happened yet. And that in itself, unmet needs of the father put the child at risk. So it's for those reasons. I did go through Michigan Court Rule 3.965. It's C, it's pretrial placement, and it's the criteria. It was the 5 questions: the substantial risk of harm, the no provision of service, contrary to welfare, reasonable efforts, and conditions away from the parent. Those questions are specifically for Mr. Ireland because we are not removing from Kendall, Ireland. So again, the standard here is probable cause. We're asking the court to authorize the petition. Thank you, Judge.
Mr. Delaney, your comments?
Yes. Let me first say, for the benefit of my client, Cody, this is a probable cause hearing. This is not the jurisdictional trial or the jury trial that you will participate in. So the burden is much lower here for the court to simply find probable cause in this matter. But having said that, there's some fine tuning that I think that the judge is aware of. And the court did indicate that treatment of one child can be considered in treatment of another, which is an interesting question, because does that apply to a situation where there is already an existing child and one child in the home has been harmed but the other wasn't? At the time of the 2024 allegations, this child was not born. So it is more consistent with anticipatory neglect. But here is the hurdle for the state. They didn't acquire jurisdiction until June. I think we had a trial in early June of this year, and then the dispositional hearing was in July. Well, here it is, early August. Cody hasn't had an opportunity to get going on this case. So to say that there is clear anticipatory neglect wouldn't be appropriate. And they can't say that it's measured from the summer of 24, because we never measure from that standpoint. For example, a dirty house. If you had a dirty house in 24 and the trial wasn't until 25, the fact that you clean the house is irrelevant. The facts are measured from the date for jurisdiction, the date of the offense. But that's different once you have jurisdiction. Then the clock is running immediately, so that when you get to termination, you are on notice. So the clock for the state didn't start until disposition in July, and here it is August. And so I think it's going to be uphill for them in a jury trial to prove that they can anticipate neglect here. It's going to be very complicated for the jury, quite frankly. But for today, the court has a probable cause determination. So it's likely the court would make that finding. I'm addressing the court and Cody. Cody, you'll have your day in court for the jury trial, but today's probable cause only. So thank you, Your Honor.
Mr. Brown.
Hi, Your Honor. This is a case, essentially, we have a brand new child after Ms. Ireland has been engaged in services and showing great benefit and doing extremely well in services. This would be in-home jurisdiction, and I understand that. One of the biggest issues she has, the court needs to now be involved with her other child. I understand that the burden is quite low, but it appears that the only real issue here is that Cody was over there once or maybe twice, but he was, first of all, never alone, and the child was never separated from his mother at those times. She was taking a brief nap. As anybody that's ever been a parent knows, when you have a 1-month-old, people need naps. He was sober at the time, and I don't think the child was in any kind of danger. And any kind of service that or monitoring was a big thing. She's being monitored. I don't think she's going to get a lot of extra services or monitoring that she's not already getting. I believe this case is probably close to an end with the other one. I think we're looking at not foster. I can't remember what it's called, family services or something, to come in the home and hopefully get that other case closed out. I mean, the burden is probable cause, but I think it's very close here.
Ms. Hansel.
Yes, I would support this prosecutor's stance on this, Your Honor.
All right, thank you very much. Question before the court is whether there is probable cause to believe that one or two of the allegations of statutory disobedience have been met in this case. The statute, as cited by the prosecutor, Mr. Sommerfeld, that the parent or other person legally responsible for the care and maintenance of the child, when able to do so, neglected or refused to provide proper or necessary support, education, medical, surgical, or other care necessary for the children, or where there was a substantial risk of harm to his or her mental well-being, or abandoned the child without proper custody or guardianship. That's under MCL 712A.2B1. Same statute, subsection B2 says the court has jurisdiction over any minor less than age 18 whose home or environment by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of a parent, guardian, or other custodian is an unfit place for a child to live. It's clear to me that Kendall and Cody are the parents, that as to the mother, that we are not alleging that she is engaged in substantive neglect of the newborn, but again, because of her past neglect plea and the court taking jurisdiction of that one, and then of her failure to meet the safety plan in this particular case, those two things put together do give me probable cause to believe that as to her, there is the statutory requirements have been met, putting the child at substantial risk of harm, or not providing proper support for the child, and then also by reason of neglect on the child, not taking proper care of given the circumstances. Probable cause, as counsel have noted, is a very low standard of proof. It's a reason to believe. It's less than a preponderance of the evidence, and quite frankly, simply because facts are contested does not remove probable cause. Ms. Ireland, I'm not going to recognize your question at this point. You're going to have to wait till after I'm done speaking. This is my time to make my determination. So whether or not we have a factual dispute doesn't remove the ability of the state to prove by a preponderance of the evidence, by a probable cause, which I believe they've done in this case. I believe that anticipatory neglect is entirely a proper way to proceed under this, and I'm very confident that it is, if not black letter law, very close to it, that neglect and abuse as to one child is proper proof of the risk of harm to the other sibling. I do not accept Mr. Delaney's timeline limitations. I believe that there is a logical and relevant inference from neglect even a year ago of a child who was at that time 5 or 6 months old to what could be neglect in this particular case if the father were allowed to have contact with that. I have seen, even despite Mrs. Ireland's assertion otherwise, I've seen very little to nothing that Mr. Ireland has done to alleviate any of the barriers in the prior case. And for me to allow him to have unsupervised and unmitigated contact with that child, I believe would be ridiculously at this point. And I have to say, just for the record, I was not and am not impressed with the mindset of Mrs. Ireland at this point, and whether or not she understands the degree of harm that could be happening to or could happen to her very young, very vulnerable child in letting Mr. Ireland have contact with the child now. Everything that she said may well be true, that he is in the beginning stages of pointing himself in the right direction, but being sober for a week, saying in one breath, but then also saying that he's weaning himself down in the next breath, doesn't give this court any good reason to believe that he should be anywhere near those kids on a regular basis. So if that is her mindset, she didn't help her cause in this case at all. That's not to say that she hasn't made good progress in other areas, but I am deeply troubled by that testimony. As to the father, Mr. Ireland, it's very clear to me from the, being the judge that heard his case a little over a month ago, where adjudication was given on the neglect charges as to the older children, that he has a lot of barriers, alcohol being one of them, that he has not addressed, and he put the kids at risk on a regular basis with his domestic violence, with his unsafe and unsuitable home conditions, and with his inattention and quite bluntly poor parenting skills, given his alcoholic stupor much of the time. And that has continued, as far as I can tell, to date. And it leads me to believe that anticipatory neglect is a very real possibility in this particular case. And there's clearly probable cause to believe that that is true as to Jackson Ireland. For all of those reasons, I'm going to take jurisdiction at this time. We'll set this matter out for another court hearing in due course. I do adopt the testimony as to the removal factors of Jackson from the father that Mr. Sommerfeld took as testimony. I do find that there would be a substantial risk of harm to the child's life, physical health, and mental well-being, given his past history and his failure to provide proof of substantial compliance with the barriers that he is were laid out in the prior court case. I do believe that there's also been no service or other arrangement reasonably available to safeguard the child from the substantial risk of harm created by the father, that there is continuing the child's residence in the home is contrary to the child's welfare for the reasons stated by Ms. Sullivan, that reasonable efforts were made to prevent or eliminate the need for removal, again, for the reasons stated by Ms. Sullivan, and that conditions away from the parent are adequate to safeguard the child's health and welfare. That is, being with mom as long as mom complies with the safety plan of keeping dad at bay unless there is a proper supervisor, and her simply sleeping next to the child is not proper supervision. So for all those reasons, I will grant in-home jurisdiction to the department, and we will remove the child from the presence of Mr. Ireland. Mr. Sommerfeld, is there anything else that you would wish to have in the court's order?
Yes, Judge, and forgive me if I know you spoke specifically about the statutory grounds 2B1 and 2B2 as it relates to mom. How do those statutes relate to dad?
I did put that on at the end of my time period. I apologize for rambling a little bit, but I did state that it was my belief that he met each of those as to, I believe that there's neglect under 2B1, and there is an unfit home environment and his neglect under 2B2 as well.
Thank you, Judge. Nothing further.
Mr. Delaney, anything else?
Yeah, I just wanted to clarify. We all know that the court has jurisdiction with the other children, and the court was covering both cases, and the court did state take jurisdiction. But to the extent the court was speaking about this case, I just wanted the record to reflect that the court's finding probable cause as to Jackson, and then the matter would be set for a pretrial and a trial for jurisdiction.
That is a correct parsing of the fine hair, Mr. Delaney. Thank you very much.
Okay. I know you had two bases to cover, and in case I didn't want that to roll into an order inadvertently.
I appreciate that. You're all correct. Thank you very much.
Thank you.
All right, Mr. Brown.
Nothing further, Judge. Thank you.
Ms. Hansel.
Nothing.
All right, that'll be the order of the court. Thank you all very much. Appreciate your
Thank
time.
you.
Sorry.
Excuse me, sorry.
Hang on just a second. Ms. Ireland has her hand up. Ms. Ireland, do you have a question?
Yeah, so there was a court order, I guess, stating on July 17th that Mr. Ireland wasn't supposed to have any visits and no one was really aware of the order. Is he still not allowed to have supervised visits through the designees that he has been given?
That's
I
what
don't
I
have
want to bring up too, Judge.
Go ahead.
I would, Wellspring Lutheran Services contacted me yesterday. Miss Hughes has been providing services for Chloe and Liliana. Apparently she did not have the order, was allowing some supervised contact. I didn't hear anything negative about that, but the existing order does prohibit that supervised contact, and I'd like to settle that issue if the court has time.
I don't have that file in front of me, so I can't confirm or deny whether it says supervised or unsupervised, but I'd be happy to talk about it right now if you wish.
Thank you. Maybe some testimony from Ms. Hughes talking about what kind of contact Mr. Ireland has had, who was supervising, and that if it is the request of Wellspring and the department for the contact to continue, and then if that's true, we would ask to change the order in today's finding of probable cause.
Ms. Hughes, would you raise your right hand, please, so we can swear you in? Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right. Go ahead, Mr. Sommerfeld.
Thank you. Ms. Hughes, how are you employed?
I'm a foster care caseworker through Wellspring Lutheran Services.
Okay, and then you're providing services to the Irelands and specifically for the child Jackson Ireland, a newborn?
Yes, I am.
Okay, has Cody Ireland been having supervised contact?
He has been having some supervised contact. I was actually made aware yesterday by Mr. Larry Brown, Attorney Larry Brown, that there was an order in line item number 30. It stated that Cody's parenting times were to be suspended and that he was to have no contact with Jackson. I was unaware of that order, so as of yesterday, I did not allow further until today's hearing. However, he had been having contact ongoing based on the same parenting schedule as he does with his daughters, Liliana and Chloe, that were being supervised by his mother and or his father at their relative home where the girls are currently placed. There's been no concerns that have been reported to me. There's been no concerns of Mr. Ireland showing up intoxicated. There is a safety plan in place, a sobriety safety plan in place between Cody, his parents, and the agency that he is adhering to. And it would be our agency recommendations that Cody, especially with Jackson being the age that he is, and as we know, developmental keystones and bonding periods, that he would be allowed to have those visits as long as they're supervised by an agency designee other than Kendall, Ireland.
All right, thank you.
Any attorney have any questions for Ms. Hughes?
Just to clarify, Ms. Hughes, so that Cody understands and is hearing this correctly, he can continue his contact with Jackson supervised by the appropriate third party?
That is correct.
Okay.
Well, that is if the court orders it. The current order does not allow it. So
Correct.
I think that's why this is being brought up for your consideration, Your Honor.
Right. So as to that, are there any other questions by attorneys for Ms. Hughes?
No, Your Honor.
No, Judge.
All right. I will add to the order in this particular case. Dad may have supervised parenting time with Jackson. How would you prefer that be worded, Ms. Hughes? By mom and or grandparents, or do you want to leave it broader than that?
No, I would like it to state that Cody has permission to have supervised parenting times with either the agency and or its designees.
All right, so I will order that Dad may have supervised parenting time with Jackson, either supervised by the agency or their designee. In this case, and if there was an order in the previous case which contradicted that, we'll amend that as well. I don't believe that there is, but I could be wrong. But in this particular case, he will be allowed to have supervised contact with Jackson as long as there is there any testing procedure that you do, Ms. Hughes, as to intoxication or use of alcohol for Mr. Ireland?
Yes, Cody does do random substance screens for our agency through forensic fluids. He does them when asked to do so. His screens his screens up to this point have been negative up to this point.
I will like that to continue, and if anyone, agency or designee, has reason to believe that he has been drinking, that supervised parenting time is to be forfeited at that time. Mr. Ireland, did you have a question? You're on mute, Mr. Ireland. I can't hear you at the moment.
I will be getting a doctor's note from my doctor to give to Kelly Hughes about what is going on. I don't know if that would be for the next court hearing.
I would say yes to that. You may want to talk to your attorney about that. But yeah, if you're going to provide information to the department, I have no problem with you doing that. But again, if you randomly screen positive, if there anybody as a supervisor has reason to believe that you're positive for alcohol, that day's parenting time is done. You understand?
Okay. Yep.
All right. So I will add that. Thank you very much for bringing it to my attention. Anything else that we need to add, counsel?
Nothing further from the department, Judge.
Nothing further.
No, thank you.
All right. That will be the order of the court then. Thank you all very much.
Thank you.